Hi, everyone, and welcome to this week's edition of Feeling Smarter. Welcome, Tim. How are you?
I'm very well, Aaron, traveling tremendously.
Well, today we're going to be talking about the importance of procedure. We get a lot of questions come through both, I guess, in our training, but also through the ordering of SMSF documents. And there is a heightened requirement, I guess, that we're seeing, Tim, through relevant case law and recent case law, even in the Queensland Supreme Court of Williams v. Williams, about the importance of getting that procedure right. So can I get you to maybe dive in a little bit about that Williams case and why procedure is becoming so much more important in the context of SMSFs?
Yeah, look, I guess the key procedure that we wanted to talk about was particularly with reference to the appointment and subsequent, I guess, subsequent removal of trustees as such, because we had a deceased member. Now, of course, when you die, then you can no longer be trustee. But we also know that the legislation provides for the capacity for your legal personal representative to be appointed, and we know it's in effect what I would classify as a bit of a soft power. So it's not a requirement under the legislation. You've got your SMSF definition, which is a legal requirement after X period of time, which is generally 6 months there. But you've sort of got this soft requirement to be able to appoint a legal personal representative to in the place of the member when they have passed away. And so it can be fairly important from a procedural point of view for the fund, because if there are issues around, say, the things like binding death benefit nominations, which in this case there was, then it's important that the way trustees are appointed is done to the letter of the law and then the letter of the deed.
Yeah, and ultimately, I think, and you reference that kind of soft reference there around the 17A. I kind of call it, the law in terms of 17A says that it's permissible to appoint someone in as that representative, but it's not a mandatory function. Now, some deeds will prescribe that as a mandated responsibility when that member dies. But again, it comes down to the very particulars of what the deed says. And the courts in all instances now will really deep dive into that documentation and work their way through right back to the establishing deed and the processes that happen throughout that to determine who are the right parties, what is the right deed, even before they begin to look at the facts of the case.
Yeah, correct. And I think this was also one of the sort of the interesting elements of this particular case, because you had one brother who had replaced his mum when she'd previously passed away, and then you had the second brother who was the executor of the dad's estate, and so he was then appointed under the LPR capacity. But one of the key issues was that they hadn't sought probate, and the deed got quite specific actually in regards to the requirements around probate before you could actually appoint the replacement trustee. So it was really it really did dig deep into the necessary process in this instance, and they didn't follow it.
Yeah, and ultimately, they'd also in this case looked at the terminology of the singular and the plural, didn't it? So we
Yeah,
saw that this outcome about the validity of a binding death benefit nomination ultimately coming down to whether it was that notice was provided to a trustee or trustees,
yeah.
and without any sort of singular means plural references or anything to that point of view as well.
Yeah, and I think this is where and we spend I know we spend a lot of time on our trust deed as such, and it's because not just cases like this, but so many in the past where people are testing the minute details attached to these elements to ensure that the correct decisions are being made, and so it's really just I guess an interesting thing that we're raising it now to say to people, there's what the law provides for, which is a little bit of a blanket approach to everything. But then to ensure yourself against, let's call it the factional family, you've got to make sure that you're doing things absolutely in accordance with the deed.
Yeah, so we've got an upcoming webinar on dealing with trustee changes, and in that upcoming session on the 27th of September, we'll go in and deep dive a little bit, not only around what we need to do and understand where we might be changing the trustee structure of the fund, whether it's from individuals to companies, or we're making changes within that trustee structure through incapacity, someone going overseas and the like, just to really help and impress on you the importance of following procedure, whether it's via the deed or even through the Constitution. So, Tim, thanks again for joining us for this week's Feeling Smarter. Look forward to you having a chat along next week as well.
No worries, Aaron. Always a pleasure to join you.
Thanks, and bye for now.